Joining us now, Federal Executive Clemency Attorney Tammy Allison and former prosecutor and criminal defense attorney Keith Lamar Jr. First, I want to hear if the court's doing anything before we go to our guests. All right, thank you, guests, for joining us here on Court TV Live. Those were the opening statements, and this is a case that's a little bit different than some of the ones we cover. We've been watching the defendant. There he is, and I think that there is so much to be said for the defense's argument that this was an accident, a horrible accident with terrible outcomes. One victim died, the other one has severe injuries, but bottom line, it was a traffic accident. He did not intend to harm these individuals. If I could start with you, Tammy, what do you think of that argument?
Thank you for having me, Judge. I think that argument it's excellent. The defense attorney put on a great opening statement by having the jury focus on the fact that it's a traffic accident, by showing that video of how Mr. Ilias was conducting himself on the body camera. He did not seem to be intoxicated. He was communicating very clearly. I think that the defense, if we're keeping score, they beat the prosecution with the opening statements there. The only critique that I have with the defense counsel is to work on the defendant's appearance. He looked more clean cut in the videos than he did in court with his white rubber bands on his braids.
He did look different. I noticed the same. I felt like he looked much younger on the video. That was just my initial observation as we were watching. Keith, if I could, you know, the state, after their closing argument at the opening statement, rather, we've been covering multiple trials. Opening statement said, we know he did not intend to do this. However, he did intend to drink and drive. That was his choice, his intention. What are your thoughts about the state's opening statement?
Well, good afternoon, and once again, thank you for having me, Your Honor. You know, I think about what the state's talking about, and it's a decent opening, but I do agree with the defense counsel. This is an accident case. It's terrible what happened. His intent was not to kill somebody, though. He was drinking, he was driving, but now they're going to see that it raised to the level of actual murder and intention. So I hear what they're saying. I get the point where they're going to go. I know that he actually intended to drink. I'm sure at one point during the trial they're going to say that, like he actually intended to drink, he intended to drive, and therefore sort of known the results that could happen. But at the same time, the charge does seem a bit heavy unless some other facts come out.
All right, Keith, let me stay with you because now I want to turn our attention to the fact of the matter that this is now a trial. Because I think as a defense attorney, you probably at this point in time have made a lot of efforts to reach some type of agreement. Are you surprised? Clearly there was no deal reached or we wouldn't be in a trial now. Are you surprised by that?
Well, you know, when I thought about that, as soon as I started hearing the opening statements, I think that the prosecutor probably didn't give the defense a chance to actually take a plea. Anything besides a murder in the first degree or a murder with intent, I'm pretty sure they would have took the deal. But he didn't give him a chance. So sometimes that happens. Sometimes you go to the state and the offer is just so high that you're kind of forced into trial, and that's what's going on right now.
All right, Tammy, as a former federal prosecutor, do you agree with that? Do you think as a prosecutor you would have made efforts to perhaps do reduced charges or a different amount of time in jail? Would you be willing to have that conversation knowing, because the facts are pretty straightforward in this case?
Yes, I agree with Keith, and I would have offered some type of plea that could assist the defendant with accepting responsibility, which he has done, and also facing a charge that is equivalent to what happened. As the defense attorney stated, this was an accident, and he stated that he's going to continue to say the word accident. And the fact that he highlighted that, yes, it's probably a little hard to understand the defendant, but not because he was impaired, because of his accent. It was an accident, and I do believe that the prosecution could have done a better job with some type of plea, but with this murder charge and assault in the first degree, as Keith stated, that is extremely high, and it probably forced the defense to have to go to trial because I don't see any attorney willing to take that type of charge for something that it sounds so far like an accident.
Now, I will say from the opening statements anyways, and we haven't yet heard evidence, that they did show it was the middle of the day, beautiful sunny weather. The golf cart crossing, you know, the defense attorney said, look, you couldn't even see those white lines yet, but approaching you can see there's golf on each side, and that's where they cross, and that these two individuals were out playing golf, crossing within the crosswalk based on the opening statements, going across in a golf cart. And so I think there's also an argument to be made. These are obviously very innocent victims, and I know that in opening, the state Commonwealth of Kentucky rather said one of them died, the other one has serious injuries, and so it is not to be taken lightly. And it is true that this person, at least from the evidence presented, was driving after drinking, some level of impairment, and crashed into this golf cart. So is it justice, and if I could start with you, Tammy, is it justice to take a case like this to trial, to let a jury make the ultimate decision?
I believe it is justice to take a case like this to trial because, as Keith and I both stated, the prosecution, it looks like, we don't have any facts right now, but it seems as if there was not a plea offered that could have made the family whole as well as the defendant. From the defense's standpoint, it appears as if they are accepting responsibility. They are not ignoring the fact that the defendant was drinking. He stated that several times in his opening. However, taking this to trial, it assists in bringing the correct type of punishment, for the defendant, the correct type of charges. The defendant's counsel stated negligence several times, which is akin to an accident, as opposed to murder or assault in the first degree, that, in my opinion, typically requires some type of intent element there, when, again, he pointed out the fact that that golf cart, what he referred to as an emoji, was not an absolute to stop or to yield. It was an accident. And I think that the defense laid that out very well in their opening statement. The prosecution also did a good job, but the defendant's counsel did, in my opinion, a better job at laying out the fact that it was an accident. And taking this to trial is going to prove that the prosecution is going to have a difficult time in meeting that beyond a reasonable doubt standard of proof for murder and assault in the first degree.
And Keith, how much would you expect that this trial might depend on experts? Because you heard the defense, for instance, say, yes, he was impaired, but we don't think as impaired as the state says that he was. Is there a lot of expert testimony to be gained in a trial like this, in your opinion?
Oh, it definitely is. Experts coming in to talk about, was he really drunk? Look at his weight, his makeup. He's a male versus a female. How much alcohol did he consume? Those experts' testimonies are going to be very important because when you look at that, that's going to let you know as a juror, okay, was this guy really that drunk? Did he really just continue to go over the edge? So especially any kind of DUI case, you're definitely going to have an expert that come in there to testify about that, testify about how much was in the system the night of. So it's a really big deal. Actually, if they didn't have it, they couldn't win the case.
All right, thank you. I appreciate that you guys are still with us. We are going to stay in Kentucky, but we are going to squeeze in a short break here on Court TV. Your front row seat to justice. You won't miss a thing.
Tonight on Court TV.
The jury has recommended Andre Warner be sentenced to death for the murder of Adam Hilaire. It's been over a year since his conviction, and now this case has come to an end. Out of everything we've seen, what had the biggest impact on this jury? We'll break down all the big issues in this case